going on? How's everyone?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky, I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? Happy Friday night. Yeah, there you go. Twelve Waffles Assemble. You guys think I don't read the comments? I read the comments. I see what's going on. Shout out to the 12 Waffles. All right. We got some court. We have the Treaty of Florida in his jury trial in front of Judge Clark. Now, I said this in the last time I covered him. He's kind of slowly walked away from the whole SovCit script. It still comes up, not as much as I wished it would, but it's still a good trial. So we're going to play it. I did take this from a 4-hour video down to a 2. There is still a little bit of dead time, but hopefully it's good. But yeah, still it was 4 hours of footage to go through, so still might be a few mistakes. Anyways, before I hit that play button, you know what to do. Hit the like and subscribe, do your jump kick backflips. Let's go.
We're on the record. State of Florida versus Josiah Marquez Beecham, case number 23CF4175. Mr. Beecham is present, dressed in his jail clothes. Assistant State Attorney Frank Sloan is present. We're set for a trial today. Mr. Beecham, you're representing yourself today. You've made that decision. You understand you have a right to have an attorney appointed to represent you?
Yes, sir.
Do you still wish to represent yourself?
Yes, sir. I was asking co-counsel for appeal purposes. That would be possible, but
Well, you can certainly have an attorney appointed to represent you if you're convicted, to represent you on an appeal. And you can have an attorney to represent you in these things. Now, it wouldn't be co-counsel, but they would represent you. But now that's up to you. Do you still wish to proceed?
yes, sir.
All right, and you're dressed out in your jail clothes. You haven't made arrangements to have anybody bring you any other clothes. Is that correct?
Yes, sir.
And you still wish to proceed, sir?
In the fort time.
All right. Mr. Sullivan? Your name from the state?
All right, I should have said this in the intro. I did jack this volume all the way up. I don't know what's going on with the court audio. It's happened in a few courts where the audio is just low. So I turned this up as high as I can go. But because of that, some of the audio is a little bit distorted, like we just heard from the defendant. Couldn't really understand what he was saying. I do apologize. I was just trying to avoid the low audio. It's the give and take that's hard to balance. Hey, thank you so much, Spade. Rachel's here. Oh, yeah, Rachel. Good to see you, Rachel. Good to see you. What's up, Mark? Good to see you too. Yep, see, Rachel's here. All right, let's go.
And so do we have all the jurors here?
Yes, sir. They are 230, 229. Give me an update on your.
Okay. And we're going on the amended information. Trafficking amphetamine 14 grams or more in possession of cocaine. Mr. Beecham, I need to ask you one question. There's a instruction, Mr. Beecham. There's an instruction in the preliminary instructions about a defendant having the absolute right to remain silent. Do you wish me to give that instruction during the preliminary instructions? And I'll read the instruction to you. In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is the duty of a defendant to prove his innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt. And the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. Do you wish to have that given this morning?
I don't maybe not being able to cross it.
No. That's just your right to remain. You don't have to have it, But if you decide not, it's up to you.
All right, I am going to let this play a little bit longer throughout, but they're not really discussing much right now, so good time to pause it. I'm not really interrupting anything. Doc Ock, it's good to see you. Because I see your name and instantly think Doc Ock, I saw the O. I'm like, what does the O stand for? His name's Doc Ock. Why isn't a D instead of a O? And yeah, like, yeah, no. Sometimes I'm an idiot. All right, let's go.
It's an instruction that is given to the jurors to make sure they understand you don't have to testify.
You can give the instruction, Your Honor.
Okay.
May I approach the clerk real quick?
Sure.
It's not about, actual cross-examination.
No, it's about you as a defendant, not you as not as you representing yourself, sir. It does not prohibit you from representing yourself or asking any questions. It's just to give the jury the information that you do not have to, that you're not required to testify, and they're not to consider that. Ladies and
All right, I skipped the jury walking in. If you guys have seen me cover jury trials before, I try to keep the jurors out of it as much as I can. You can see them a little bit in the bottom right panel, the bottom left of it. You can see them a little bit. Just try not to pay attention. Also, Dale Grits, thank you so much for the 4 months. You are awesome. I appreciate it, and thank you also for the generous. Was it Venmo? Yeah, Venmo. And yeah, I'm glad you loved the road trips and the interviews. Thank you so much for the membership milestone and the generous Venmo. Thank you so much. All right, let's keep going.
gentlemen of the jury, you have been selected and sworn as the jury to try the case of the state of Florida versus Josiah Marquise Beecham. This is a criminal case. Beecham is charged with 2 counts, trafficking of amphetamine, 14 grams or more, and possession of cocaine. The definition of the crimes charged will be explained to you later. The state's charging document, which is called an information, is not evidence and is not to be considered by you as any proof of guilt. It is the judge's responsibility to explain the law to you. It is your solemn responsibility to determine if the state has proved its accusations beyond a reasonable doubt against Mr. Beecham in accordance with the law that I provide to you. Thus, the province of the jury and the province of the court are well defined, and they do not overlap. This is one of the fundamental principles of our system of justice. Mr. Beecham has the right to be represented by an attorney or to represent himself in this trial, as do all criminal defendants in this country. He has exercised his constitutional right to act as his own attorney. This decision should not affect your consideration of this case. Before proceeding further, it will be helpful to understand how a trial is conducted. At the beginning of the trial, Mr. Sullivan and Mr. Beecham will have an opportunity, if they wish, to make an opening statement. The opening statement gives Mr. Sullivan and Mr. Beecham a chance to tell you what evidence they believe will be presented during the trial. What they say is not evidence, and you are not considered as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits also may be produced as evidence. After the evidence has been presented, the attorneys will have the opportunity to make their closing arguments. Following the closing arguments by the attorneys, the court will instruct you on the law applicable to the case. After the final instructions are given, you will then retire to consider your verdict. You should not form any definite or fixed opinion on the merits of the case until you have heard all the evidence, the argument of the lawyer, or the argument of Mr. Sullivan and Mr. Beecham, and the instruction on the law by the judge. Until that time, you should not discuss the case among yourselves. Your verdict must be based solely on the evidence or lack of evidence and the law. I now instruct you not to communicate with anyone, including your fellow jurors, about this case. No communication includes no email, text message, tweeting, blogging, or any other form of communication. You cannot do any research about the case or look up any information about the case. If you become aware of any violation of any of these rules at all, notify the bailiff of the violation. During the course of the trial, the court may take recesses, and you will be permitted to separate and go about your personal affairs. During these recesses, you must not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you in your presence about this case, tell him or her that you're on the jury trying the case, and ask that person to stop. If he or she persists, leave that person at once and immediately report the matter to the bailiff, who will advise me. All cell phones, computers, tablets, or other types of electronic devices must be turned off while you're in the courtroom. Turned off means that the phone or other electronic device is actually off and not in a silent or vibrating mode. You may use these devices during recess, but even then, you may not use your cell phone or electronic device to find.
All right. Yeah, I do realize I kept in the jury instructions. You're asking for 1.5 speed. I can't do that because I've already made the video. I would have to do that on the video, so I can't recompile it during it. Unless somebody knows how to do it on StreamYard, I don't. There might be a control somewhere, but I'll put up a poll, and if you guys want me to skip through, the boring stuff, the jury instructions, I can. So I'll put up a poll and see if you guys want that or not. Because I know some people like it because, it's, if you've never had jury duty before, it can be interesting. So I'll put a poll up. If the majority says yes, skip it, then I'll skip it.
Find out any information about the case or communicate with anyone about the case or the people involved in the case. Do not take photographs, video recordings, or audio recordings of the proceedings or of your fellow jurors. After each recess, please double check to make sure your cell phone or electronic device is turned off. At the end of the case, while you're deliberating, you must not communicate with anyone outside the jury room. You cannot have in the jury room any cell phones, computers, smartwatches, or any other electronic devices. If someone needs to contact you in an emergency, the court will receive messages and deliver them to you without delay. The case must be tried by you only on the evidence presented during the trial and in your presence and in the presence of the defendant, the attorneys, and the judge. Jurors must not conduct any investigation of their own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you're at the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. If you would like to take notes during the trial, you may do so. On the other hand, of course, you are not required to take notes if you do not want to. That will be left up to you individually. You have been provided a notepad and pen for use if you wish to take notes. Any notes that you take will be for your own personal use. However, you should not take them with you from the courtroom. During recess, the bailiff will take possession of your notes and will return them to you when we reconvene. After you've completed your deliberations, the bailiff will deliver your notes to me. They will be destroyed. No one will ever read your notes. If you take notes, do not get so involved in note-taking that you become distracted from the proceedings. Your notes should be used only as aids to your memory.
All right, most of you are saying skip, so I'll fast forward the jury instructions. Sorry for everyone that wants to watch it. It is boring. He's just going through their constitutional rights. But while I am paused, I think Creighton said, "How is he allowed to be wearing his jail uniform?" I did answer this in the last video, but I should have said it to this one too. He's representing himself, and you're right. A lot of other courts, they won't even let the juror come up if he doesn't change clothes, because we've seen it before where he's refused to change, and the judge won't even allow him in the room. But in Florida, it is up to the defense to coordinate his change of outfit. Because he's representing himself, he didn't do that. And it's come up, I think it came up at the very start of this video. Also, it came up a couple times in the last video where the judge actually said that to him. So, all right, now that I said that, I'll skip ahead a little bit. You know what? I'll just skip ahead till I see the prosecutor standing up.
So as to consume as little of your time as is necessary.
Baggies.
Nope,
And there
too
were
far.
these.
So as to consume as little of your time as is necessary for a fair and orderly trial of the case. Mr. Sullivan, whenever you're ready.
Thank you, Your Honor.
May call your first witness. I'm sorry, take your oath in a second.
Thank you. On November 11th, 2023, this defendant, Josiah Beecham, was found by Officer Richard Ziff of the Panama City Police Department to be in possession of a trafficking amount of methamphetamine as well as a quantity of cocaine. You're going to hear from Officer Richard Ziff today. He's going to tell you that on November 11th, 2023, the defendant was driving along Beach Drive, not far from here, when the officer conducted a traffic stop on the vehicle that the defendant was driving. He made contact with the defendant, and during the course of this traffic stop, ultimately ended up searching the car. When he searched the car, he also searched Mr. Beecham's person, and he's going to tell you what he found. He's going to tell you that in the back seat, just behind the driver's seat, within reach of the driver, was Mr. Beecham. He found a couple containers. In one container, there were several white powdery substances in baggies. In another container, there was another similar powder in baggies. And there were these pill-like substances that were ultimately sent to the Florida Department of Law Enforcement and determined to be methamphetamine. What you're going to hear is that the one substance in one of those containers was sent to the Florida Department of Law Enforcement, tested positive for cocaine. And you're going to hear from the analyst today. His name is Sam Catalani. He's going to tell you about that. He's going to tell you that not only did he find that these substances were methamphetamine and cocaine, but the methamphetamine in this case actually weighed 15 grams, which is above the threshold for trafficking that we talked about on Monday, which was 14 grams. You're also going to hear from Officer Richard Ziff that the one container that held the multiple baggies of the white powder that was found with the cocaine and the methamphetamine, the officer, when he searched Mr. Beecham's person in his front right pocket, he found the exact same baggie, the exact same powder in that as well. Mr. Beecham told you Monday during jury selection when we talked about possession that there's a knowledge element. And he's correct, there is. In this particular case, the evidence that you will have that Mr. Beecham had knowledge of the substances in the back seat is because he had that exact same thing in his pocket as well. And you're going to hear that from Officer Ziff. This is not going to take all day. This is not a complex case. It's pretty simple. Those are the two witnesses I expect you to hear from today. And then after you hear all the evidence, the judge will give you the law. He'll read you the instructions and tell you what I have to prove beyond a reasonable doubt for you to find the defendant guilty. And what he's going to tell you is that for the first count, trafficking of methamphetamine, I have to prove three things beyond a reasonable doubt. The first is that the defendant knowingly possessed the substance. The second thing is that that substance was methamphetamine. And the third thing is that the methamphetamine weighed more than 14 grams. For count two, possession of cocaine, I have to prove two things beyond a reasonable doubt. The defendant knowingly possessed the substance, that substance was cocaine. After you've heard all the evidence in this case, there won't be any reasonable doubt that the defendant's guilty of these charges. And at that time, I'm going to come back before you. I'm going to ask you to find the defendant guilty as charged. Thank you.
Mr. Beecham?
That's a great question. You asked it right in between the prosecutor and the defendant talking. I think it comes up because they bring up the officer that pulled him over, and I'm sure it comes up. But I will tell you that he ran over a curb or he crossed the center line. So no, it wasn't the SovCit stuff that got him pulled over, but he did use it once he got pulled over. We don't get to see the body cam, unfortunately. I did try to search for it. It's not on YouTube. No one's found it, or no one's gone looking for it, I should say. Yeah, no one's actually got it from the police station. But it's not in here. That would be a great video to watch. But yeah, he got pulled over for swerving, and that's when everything happened. But you'll hear more about that here shortly. Also, while I'm paused, MB, thank you so much for the PayPal. That was generous of you. Thank you so much, MB. I always get happy when I see you in chat, so thank you for being here.
Excuse my time, ladies and gentlemen. I wasn't able to make the bail, couldn't afford it. Ladies and gentlemen of the jury today, you merely heard the related allegations from the prosecutor. And as he said, it's not my duty to prove my innocence, but the state's duty to prove my guilt beyond a reasonable doubt by meeting every element of the case. And the elements of this case, like he said, is to have the knowledge and the dominion and control over the drugs. You'll hear allegations also as well from the police officer. As y'all heard Your Honor speak today, we're in the age of technology. And there's plenty of technology exists, such as body-worn cameras that the police have, that the police actually had on them. And the body-worn cameras, along with the actual evidence that was presented, does not prove me guilty of anything. It actually prove my innocence. The officer in this case, as the state already knows and admitted, did commit false statements.
Objection, Your Honor.
Sustained. Go on, Mr. Booth.
And, well, yeah, the officer in this case is gonna make allegations that can't be proved beyond a reasonable doubt. And, a camera would easily prove anything to anybody and show what happened. But as far as an allegation, as well as a charging document and submitted evidence, would actually prove the allegations better. And so today you're gonna see evidence probably presented from the state, and the witnesses will come in to testify. And I'll let you guys see a copy of, or hear the testimony of the state and all the witnesses, but actual documented evidence that was documented into evidence, you'll see I actually had no drugs on me, as well as the video footage. There was no drugs on me, so the officer just, made that statement up. But out of multiple officers that were on the scene, but only one's coming. So that'll be all for today, right now, and I thank you guys for coming over here today.
Mr. Sutton, they call you for witness.
Some state calls Richard Ziff.
Yep. Wasn't good. Wasn't terrible. Like I said, he has gone away from the SovCit script. Again, it does come up when the officer is talking to him. You could tell the officer doesn't like this guy. I will tell you that right now. He's kind of annoyed that he's at a jury trial for this, but you'll see what happens. Yoshi! Taco. Sorry. Taco and Yoshi. Hope you're having a great night. Thank you so much. King Yoshi L. Bay does not condone this guy's action. And if you guys don't know, we're talking about a bearded lizard. And he's got his own fez. So I got to see him last night. It was a cool picture. Thank you so much, Taco, for sharing that. All right. Wait. Okay. I'm going to sound really bad because everyone else knows the answer to this question. Are you Taco or are you Yoshi? And which one's your lizard? Because I don't know. Because I got caught up there. I'm like, oh, man. I think everyone was calling you Taco last night. But were they calling you Yoshi? All right. Let's go. Sorry for calling him bearded lizard. I hope I don't get hunted. I might have a mark on me now. So sorry, Yoshi. I am so sorry. The bearded dragon. The coolest bearded dragon of every dragon that's ever walked this earth. Okay, hopefully that helps.
I do. You have a seat. Speaking to the microphone, and Mr. Sullivan, you may inquire whenever you're ready.
Thank you, Your Honor.
Hey Vince, I want to let you know that I'm watching your comments and you're fine. I just don't want to bring them up on the screen because of what you're talking about, because I don't want to throw your business on the screen where other people that aren't in the chat will see them. But I am reading your comments, and yeah, I'm proud of you, man. I'm proud of you.
Morning, sir.
Morning.
Can you please introduce yourself to the jury?
Officer Richard Ziff, Panama City PD,
How long have you worked for the Panama City Police Department?
2 years.
And where did you work previously to that?
Garfield County Sheriff's Office in Colorado and El Paso County Sheriff's Office in Colorado.
And how long were you a law enforcement officer in Colorado?
It was all law enforcement from 2013 to 2022 in Colorado.
I want to take you to, well, before we get to that, what are your general duties with Panama City Police Department? What do you do?
I patrol the city, respond to calls for service. I'm drive around, be proactive, prevent crimes, deter crimes, make arrests, interact with the citizens of Panama City.
As part of your job duties, do you routinely do traffic stops and things of that nature?
I do.
We'll take you to November 11th of 2023. Did you conduct a traffic stop on that date?
I did.
Where was that traffic stop? Where was that located at?
It was going to ended up on Fairland Avenue and West Beach Drive.
And what was the basis for conducting that traffic stop?
When I turned on to West Beach Drive from Balboa, I witnessed a vehicle in front of me that was having a hard time maintaining its lane. Eventually the vehicle started drifting over the traffic control device, which is the center median solid lines. So at that point, I activated my overhead blue lights to initiate the traffic stop on the vehicle, with the vehicle coming to a stop on West Beach Drive and Fairland Avenue while it was, when it came to a stop, it actually drove over the curb.
When you say the center,
Your picture probably won't be. I don't think YouTube is going to remove your picture. I don't think they'll do that. I've seen people with, Spider-Man, Batman logos. I don't think they'll remove your picture at all. Maybe me having it on screen for a long time might be a bad idea though.
median traffic control device, you're talking about the yellow lines.
Yes,
Ultimately, when you conducted the traffic stop, did you make contact with the driver?
I did.
Were you able to determine who the driver was?
It was Mr. Josiah Beecham.
Do you see that person in the courtroom today?
I do.
Can you identify him?
He's to my right.
Let the record reflect that he said the witness has identified the defendant.
Record so reflect.
When you made contact with Mr. Beecham, did you do your standard license registration, all that kind of stuff?
I introduced myself as Officer Ziff, Panama City PD. Told him the nature for his stop, which is because he was having a hard time maintaining his lane. And immediately told him as well that I detected the odor of marijuana coming from within the vehicle.
Ultimately, as a result of this traffic stop, did you end up searching the vehicle?
I did, because I developed probable cause to search it after I had plain smell of marijuana.
Did you also ultimately end up searching Mr. Beecham's person himself?
I did.
I want to talk a little bit about what you found. If you could look, there should be a couple photographs in a little folder for me. I apologize, they're not there. May I approach, Your Honor?
You may approach.
I'm showing you what's been pre-marked for identification as State's Exhibit 1A, B, and C. If you could take a look at those three photographs, please. Those photographs accurately depict what you found when you searched the vehicle and Mr. Beecham's person.
Yes.
Around this time, the state removed State's Exhibit 1A as an alpha through 1C as in Charlie into evidence.
Any objection?
Jake, Your Honor. That was more evidence, that's all I'm asking.
I'll overrule that objection. States A, is that the objection? There was other exhibits? Mr. Beecham?
Yes, Your Honor, that wasn't actually, submitted into evidence.
Okay. I'll overrule the objection based on that. It states A, what was that? States A1 through?
1A through C.
1A through C. You may publish.
He wasn't actually charged with the marijuana though. He was only charged with the two things. They bring it up a lot here. I don't really know why, but it's not one of the charges. It's not one of the charges. All right, while I'm paused, thank you so much, Sandy. I appreciate it. And I am doing well. I hope you're doing well as well. Thank you for the super chat.
Officer Zip, I want to talk about States 1A here. We've got a couple of different things in this photograph. We've got these two containers in the front, and then we've got a bag of some pill stuff in the back. First off, were all of these three items located in the same place?
No. 1A and 1C were located in the bag behind the driver's seat. And then
I get what you're saying. I want to talk about just 1A.
Oh, yeah.
The three items that are in this particular photograph in 1A,
Yes.
were they all located in the same place?
Yes.
And where were they located at?
They were in a bag located behind the driver's seat.
I want to talk about the item, the container on the left in this photograph.
Yep.
Was that item collected?
Yes.
Was it ultimately submitted into evidence?
Yes,
And was it sent to the Florida Department of Law Enforcement?
yes.
May I approach, Your Honor?
You may approach.
I'm showing you what's been pre-marked for identification of State's Exhibit 2. Do you recognize this?
Yes.
Is this State's Exhibit 2 the contents of the container on the left in photograph 1A?
Yes.
Your Honor, this time the State would move State's 2 into evidence.
Any objection?
Jack, what is
You'll show Mr. Beecham, please.
The container on the left in my photograph.
Hey, happy birthday, Kathy.
Beecham,
Thanks
anything
for
else?
hanging out with us tonight. Because I'm like Jack Benny, 39 and holding. You know what? Happy birthday. Happy 39th birthday. I hope you're having a great day and you enjoy the rest of your evening. And again, thank you so much for hanging out with us tonight.
Or now accept State's Exhibit 2 into evidence. You may publish whenever you're ready.
Thank you, Don. I want to talk about the item at the top in photograph 1A, top of the photograph. And I'm going to skip to 1C real quick. Is this baggie the same item that was at the top of the photograph in 1A?
Yes.
Was this also collected and sent to the Florida Department of Law Enforcement?
Yes.
May I approach, Your Honor?
You may approach.
You recognize this?
Yes.
I'm showing you what's been marked for identification in State's Exhibit 3. State's Exhibit 3, is that the items that are depicted in State's photograph 1C?
Yes.
And that was taken from the same baggie as, or the same bag in the back seat as the item that was collected in State's Exhibit 2.
Yes.
Around this time, the State would move State's Exhibit 3 into evidence.
Any objection?
I see what it is.
Yes, sir. Mr. Stump, you're short. Mr. Beecham, please.
Those were meant for you, not your nurse. I was trying to make you laugh, but I'm glad I made her laugh as
Any
well.
objection?
No, sir.
All right, State's Exhibit 3 will be accepted into evidence. You may publish whenever you're ready, Mr. Sullivan.
Now, I want to go back to when I talked about the container on the right. What was contained in the container on the right? Can you describe the substance, what it looked like, and how it was packaged?
It was a white powdery substance that was packaged in a clear plastic baggies, individually wrapped.
Were there multiple individually wrapped baggies?
Yes.
And that was found in the bag, in the back seat, along with State's Exhibit 2 and 3.
Yes.
I want to talk about the photograph States 1B as in Bravo. What are we looking at here?
It's another bag that was located in Mr. Beecham's right front pocket when I was doing a probable cause search of his person.
So the item in this photograph was actually taken from Mr. Beecham's pocket.
Jack,
Yes.
What's the objection?
the evidence is not proven. Really,
He's just asking a question now, so I overruled the objection. Yeah, you can make another objection if there's any introduction.
So this photograph, this item was actually taken from Mr. Beecham's pocket.
Yes, it was found in his right front pant pocket.
And the substance and the packaging of this item, was it identical to the substance and items in the container on the right in States 1A?
Yes.
Now, I want to talk to you a little bit about, were you wearing a body camera when all of this happened?
It was.
And
All right, I will always pause it for birthdays. So, Patty, happy birthday. Hope you had a great day and happy anniversary as well. That's awesome. 45th anniversary. Wow. Congratulations. Congratulations on the anniversary and happy birthday. I know I'm behind on, I think I'm behind on Super Chats. No, I'm not. No, membership milestones. I'll announce the membership milestones when they switch, when the defense comes up to talk.
was your body camera on at some point in time?
Yes.
At some point in time, did your body camera get turned off?
It did when I pulled him out of the vehicle. His elbow hit my body cam and deactivated it.
when you pulled him out of the vehicle, you pulled him out of the vehicle and attempted to put him in handcuffs and detain him, correct?
Yes,
Was Mr. Beecham cooperative in that process, I guess?
no,
Did he struggle a little bit?
yes,
And during that struggle, is that when your body camera got turned off?
yes,
At some point in time, did you realize your body camera was on or it was off and turn it back on?
yes. The moment I realized it was off, I immediately turned it back on and informed my supervisor that body cam got turned off.
And by the time that you had realized it and turned it back on, had you already begun searching?
Yes,
Had you already found the items that we've already talked about?
yes,
So your body camera footage doesn't actually capture you searching the vehicle or searching Mr. Beecham?
unfortunately, no.
Your Honor, I've got no further questions at this time.
Mr. Beecham?
All right, this is when the fun begins. This is when the fun begins. All right, let's get these membership milestones. Tuna, NM Tuna. I think I said this last time you did this. Is NM your first? Are they your initials and then Tuna? I don't know. But thank you so much for the 3 months, Tuna. I appreciate it. And also, Grizzly Old Fart, thank you so much for the 3 months as well. 2 double 3 months. It's awesome. That almost makes a half a year. You guys are awesome. Thank you so much. Also, Natasha, thank you so much for the PayPal. I appreciate it. That was very generous of you. I appreciate it. You guys are killing it with the PayPals tonight. All right. Yep. Let's keep going. And I know everyone who's watching from YT, you can't really tell what these drugs are. So be nice to me, please.
Sit there at your desk, or you can have go to the podium wherever you feel comfortable.
So, made the traffic stop, and when you made this traffic stop and approached the vehicle, how many occupants was in the vehicle?
It was you and Mr. Wheeler.
2 occupants.
Yes,
Did I challenge you in any manner or ask for any, challenge the reason why you stopped?
You challenged me as far as why I stopped you, my authority to stop you, and you immediately wanted me to have Bay County Sheriff's Office arrive on scene because you did not want to speak with me. You also stated that I was violating the treaty between you and the state of Florida several times.
So I asked you to call the sheriffs, right?
Yes,
And then after you said this is not the sheriff's jurisdiction, then I also asked you to call your supervisor.
yes,
Okay. And calling backup is a safe concern for multiple individuals, and it's easier for more officers to contain and see more people, right?
right.
All right. At a preliminary hearing, you testified as well.
Objection, Your Honor, proper impeachment.
Sustained.
I'm not talking about the false allegations, Your Honor.
We're gonna have to rephrase your question.
At the point when you removed me from the vehicle, did you have eyes on the passenger?
I lost eyes on him because I had to focus on you, and my officer safety involved me having to safely remove you from the vehicle.
The drugs were allegedly found in what type of?
A clear plastic baggie that was located in a backpack behind your seat.
Is that a brown bag?
No, they were in a clear, each of them were wrapped in clear plastic baggies in a backpack behind the driver's seat.
Well, in your narrative.
Objection, Your Honor, proper
At the
impeachment.
preliminary hearing, you
Sustained. It's improper impeachment. You have to rephrase your question.
okay, did you ever testify that they were in a brown bag, or write in your narrative that they were in a brown bag?
I stated they were in a bag.
Can I approach you?
Yes, you may approach.
Is this your narrative report?
Yes,
Could you read the top of that for me?
a brown paper bag.
Thank you. did you write this?
Yes,
Does it help you remember?
I mean, it's my report.
So they were in a brown bag?
Brown bag was located in the bag behind the driver's seat.
And the containers in the picture, you want to see this? You already have a copy. And all the collected items were seized and documented in the evidence, right?
Yes,
Cocaine in the evidence? Just a minute, yes. That's not the bag, so.
So, you said cocaine?
Yeah.
Yeah, cocaine's right there.
That's not the bag, right?
I don't
Is it the bag, the one that's in this exhibit? Eight. Where is it?
I'm not losing difference.
Where is it?
What I've moved into evidence is sitting right up there.
And the evidence that you submitted, what all was found in that brown bag? Would you relate that to the court?
there was the two items in front of me, and then there was bags individually wrapped that contained a green leafy substance that had the odor, distinct odor of marijuana. And it was individually wrapped as well.
Was that all that was found?
There was these items and the white powdery substance as well.
No, Jesus.
And there's also the oxy.
Oxycodone.
Yes.
What was it? How many bags were it?
Per the evidence sheet, there shows to be
Mr. Beecham, you need to back up just a little bit, okay?
one that was entered for 5 and then one was entered for 8.
So it's two separate bags?
Yes.
And what about the cocaine?
Shows here that the cocaine was entered all together in one submission.
All together in one submission?
Yes.
It's, actually, if you look at it, it's
Yes.
two different.
So the way we did it was we entered all the cocaine together, got a total weight of all the cocaine. There's not any record of how many bags there were. It's just a record of how much the total weight was of the cocaine. That's how we determine charge amount, is if it's going to be based on what the weight is.
So one item is something different from something else. You know, say cocaine here and cocaine here.
One's crack, one's cocaine.
What's the objection?
I think it's improper to questioning that, I don't know what he's getting at. I'll withdraw my objection.
Mr. Beecham, you can continue.
Okay. So you say you put all the
All right, that's a new one right there. Where the defendant just walked over to the prosecutor, like, I don't know where he's getting at. Like, I don't know, objection, he's leading, I don't know, where's he going with this? And he just walks over, he's like, well, this is what I'm going to ask him, and this is what I'm getting at. He's like, all right, well, okay, I withdraw the objection. But yeah, someone said earlier, this guy's not doing a terrible job. He is not. He's not doing the best job. I don't want to say he's not doing a good job, but he's not doing a terrible job. He's right there in the middle. He's mostly dropped the SovCit stuff, and he's focusing on the charges he was charged with, which is, yeah, that's what he's, the prosecutor's trying to prove. So he's not trying to prove, I got pulled over illegally or anything. He's fighting the charges based on how they're written in the law.
drugs together.
All the drugs are all similar. So you got two different types of the white powdery substance. You got the one that was on my right here, which is a more chalky white. And you got the white powdery, which is going to be the other stuff that was found in your pocket as well in that bag.
Okay, and you say you submitted all the stuff together. What stuff you put together?
All the stuff that was powdery, you put that as well as marijuana. It's all gets put together to get a total weight.
Okay, well, the evidence don't reflect that with the oxys, that didn't go together.
Because that's not based on the weight, that's going to be based on the
The objection
Residual amount.
is sustained, officer.
So it's nothing logged here saying that it came out of my pocket.
That's just an evidence sheet.
Okay. Now, all the evidence you guys collected, you said your body camera wasn't on when you found any of it.
No, because your elbow hit me on my body cam, deactivated my body cam.
Could you, could you demonstrate that to the court? Do you have your camera on you today?
Yes, my body cam's on me right now.
How does you actually activate it? How does it turn on and off?
When the body cam is actually on, for the purpose of being in court, my body cam's off right now. So on my body cam, there's a button right here in the front that my index finger is touching right now. When I push that, that activates my body cam. Push it again, it turns off the body cam. So when I initiated the stop, immediately my body cam turned on. When Mr. Beecham refused to come out of the car, I had to remove him from the car, and because he was not cooperative with me, I swung him around the car to put him against it to control him. His elbow, left elbow, went into my body cam button, deactivating my body cam.
So it's just a slight push of the button that deactivates.
Based on the amount of pressure, yes. Like I said, I had to push you against the car to control you because you were not cooperative.
And all these items were they analyzed for fingerprints. I see a container here. It was a brown paper bag. Were they analyzed for fingerprints? Did the fingerprints come back as mine?
I do not know what FDLE did with the containers. All I know is that the items were in your control. They were within your reach.
They were in my control and in my reach.
Yes.
You said they were behind the seat on the floor.
No, they were behind your driver's seat in the passenger seat.
They were
Behind, so the back seat on the driver's side is where the items were located.
okay on the floor.
But then your car was a mess. It was behind the driver's seat.
Okay, so it was a lot of stuff in the car.
You had a lot of stuff in the car.
Okay, and you said my car. Was that actually my car?
It was your girlfriend's car.
It was a girl car.
Your girlfriend, she showed up on scene, told us that she was your girlfriend. You even told us on scene that it was your girlfriend.
Okay, just making sure it wasn't my actual car.
That's the next one.
I'll have an answer to the question. Let's move on.
And you said you lost sight of the passenger, and you didn't get these items analyzed for any fingerprints to prove that they were actually mine.
No,
You said you mixed all the substances together.
all the substances that were all the same, such as the white powdery substance that I field tested on scene as cocaine, were yes, put together, as well as the crack cocaine and the oxycodone, which was identified via pill finder.
Okay. So mixing drugs together, is that proper policing or keeping them separate to clearly identify what they are as far as the FDLE report?
Our policies have us placing all the drugs that tested positive the same, putting it all together so we can get a total weight of the drugs. We cannot get a proper weight if we keep them in the small baggies because it ends up adding weight to it. So your baggies were all put into a separate evidence for paraphernalia.
So a field test kit will prove what the drug is, and you said you field tested the pills here as well. What did they field test come back as?
I don't need to field test the pills. The pills had identifying or numbers on them. The oxycodone.
No, not those, the colorful ones that's in the exhibit.
Oh, these ones? The exhibit number 3?
Yes.
So those tested positive for fentanyl, but the lab came back as meth.
So the field test is not always accurate, right?
Not always, but these items did come back from FDLE.
Okay, exactly. And so that's why I don't think it's proper police work to mix the drugs. That's called co-mingling.
If you want to change our policies, you can come to the Panama City Police Department.
You'll just answer the question instead of giving a narrative.
It's our policy.
It's the policy to mix the drugs on the scene.
That's the answer, Your Honor.
Staying, move on.
Yes, sir. And, okay, the original charging sheet that I have, did you, submit those charges?
I did.
Do you remember what I was actually charged with?
Objection, relevance.
Staying.
Did you tell the court what I was charged with today?
Objection, relevance.
The
Staying.
relevance is so they can know what I was originally charged with.
Y'all approach.
Okay.
Can y'all approach? That was really quick. That was really quick, and with his southern accent, yeah. Can y'all approach? Yeah. So for everyone that came in late, I don't know if the officer testified here or in the preliminary exam. I get them both confused now because it feels like it's the exact same thing. But the district that the officer works in, or his department's better, not district. They don't have dash cams on their vehicles, so there's no dash cam. His body camera, I hope I'm not ruining this because I think he said it already. The body cam footage isn't there because it was turned on, but because they had a little scuffle pulling this guy out of his car, the defendant's elbow actually turned off the cop's body cam. So all they have is him walking up to the car and trying to pull him out. So they have nothing of the drug search. That's what's going on here. And the defendant, he's doing a decent job, and he keeps calling him out on that. It's like nobody there had body cam footage of this, and my magic elbow turned your body cam off, and so you don't have anything of the search. So he's doing a good job of really honing in on that. So again, he's not doing an awesome job. He's not an attorney. But him giving up on the SovCit stuff and actually focusing on what he needs to focus on, he's doing a good job on that.
Have you ready, Mr. Beach?
So
I muted my mic, and then I saw your question. I jacked up the volume, but to as high as I could go when I was editing the video, but I turned it down because on my side on here, I'll turn it up a little bit more. Hopefully this helps, but it's just when it's too loud, it's a little distorted. So I keep trying to balance it. So hopefully this helps a little.
you said none of those stuff was analyzed for fingerprints.
No.
You assume the stuff was mine.
It was in your control, and then, like I said, you had a clear plastic baggie of the white powdery substance, which matched the same substance that was found in the bag behind the back seat, or behind the driver's seat in the back seat.
Okay. And the body camera is not on.
Objection, that's the answer.
I overrule the objection. You can ask it again.
All right. If you were to say exhibit A and exhibit B, you say you mixed that all with the stuff that was in exhibit A.
In the right container, yes.
So why is the pictures still separate?
Because we take pictures of all the evidence we have for this type of purpose, and then we mix it together with weight.
I was looking for that. When I was editing this, I knew because I was writing down the timestamps, I was fast forwarding, and I was not in front of my computer when this happened, so I didn't have my notepad open. But yeah, there you go. Bufflip just joined it for a second. That was Bufflip's voice, because Judge Simpson goes on recess for an hour and a half, and I forgot I even had the tab open.
In the right container, yes.
So why is the pictures still separate?
Because we take pictures of all the evidence we have for this type of purpose, and then we mix it together, get a total weight.
No, I had Judge Simpson's window open, and I forgot I did, because he literally was on a break for about an hour and a half.
Any redirect?
Yes, Your Honor, may I approach?
You may approach.
Officer Zip, I'm going to show you what's been marked for identification purposes as State's Exhibit 4, 5, 6, and 7. So earlier when you were testifying, I asked you about some of the items that you found in the vehicle. And we talked about the suspected cocaine in the container on the left, suspected cocaine in the container on the right, and the suspected methamphetamine. There were those multicolored pill type things, correct?
Yes.
Okay. Mr. Beecham asked you some questions about some other items you found. I'm showing you what's been marked for identification in State's Exhibit 5 and 6.
Yes.
Do you recognize those?
Yes, that's the oxycodone.
These are the oxycodone pills that you found in the same location.
Yes.
These were not tested by FDA, correct?
I do not believe they were.
I'm showing you what has been marked for identification in State's Exhibit 7. Do you recognize that?
Yes.
What is that?
It's the green leafy substance that I identify as marijuana based on a distinct odor.
And this was also found the same location?
Yes.
And this was not tested by FDA, correct?
No.
I'm showing you what's been marked for identification in State's Exhibit 4. Do you recognize this?
Yes.
What is this?
That's going to be the white powdery substance that's going to be in 1A on the right, as well as the white powdery substance that was in his pocket.
Madam Clerk, if I could have the screens again, please. So I want to clarify this a little bit. I want to clarify your testimony about mixing things together.
Yes.
So the items, let's start with 1C. That baggie, when you took this photograph in 1C, this photograph was taken as the items were found, correct?
Yes.
So they were not mixed together in this baggie by you.
No, they were all, it was found just like that.
And this baggie, this photograph again was taken to document the item as it was found in Mr. Beecham's pocket.
Yes.
So this baggie, nothing was added to it or taken from it prior to this photograph.
No.
In these photographs, in these two containers, this photograph was taken as the items were found
Yes.
to document the condition that you found in them.
Yes.
Nothing was added to either one of these containers or taken from either one of these containers.
No, the containers are exactly found. The picture were taken exactly the way they were found.
Now, when you talked about what you mixed together and added together, we're talking about the clear the powder in the clear plastic baggies in the container on the right,
Yes.
along with this baggie, correct?
Yes.
Those baggies were mixed together because they were all the same white powder.
Yes.
And that's what's in State's Exhibit 4, correct?
Yes.
All right, it's time to state remove State's Exhibit 4 into evidence.
Any objection?
Yes, I object, Your Honor, because officer did say that field test is not an accurate test. It actually also tested fentanyl, positive for fentanyl for the pills. And that substance is not proven to be a separate substance that was actually found on fire.
State's Exhibit 4, is that whatever the contraband was found in the Mr. Beecham's, was allegedly found in Mr. Beecham's pocket and in the back of the seat?
Yes, Your Honor.
So what I'm gonna do is I'm gonna sustain the objection at this time, I assume there's someone else that's going to testify as far as that substance. Is that correct?
May we approach, Your Honor?
Sure. What are you asking me, in evidence?
Your Honor, at this time, State of State's Exhibit 4 in evidence.
That'll be over, objection. State's Exhibit 4 will be accepted into evidence.
I believe that's all the questions I have for the officer. Thank you.
Any other questions, Mr. Beecham?
Yes.
Okay.
Do you remember how much, cash was alleged to be on the driver?
I do not.
Did any of your other fellow officers, body camera was on?
After they showed on scene, yes.
These drugs, you say were all individually wrapped?
Yes.
Didn't submit anything for print?
No.
Is there a reason why not?
We generally do not submit for prints, especially when I can prove that it was already in your control.
Could you explain that control?
It was within your arm's reach. And on top of that, like I said, the bag that's on the camera or on the TV monitors was located in your pocket was the same substance that was found in one of those bags.
Okay, and how sure you were of that, saying that there's no evidence of that?
I'm pretty sure.
Pretty sure.
100%.
100%.
Yes.
So how are you 100%? Explain that.
Like I said, it was within your arm's reach. You had the same items in your pocket that was in the bags.
Is it the same item or items?
The bag that was in their right front pocket of your pant pocket is the same bag, same type of item, same wrapped item that was in the baggies. It was in the bag in the back seat.
But you didn't keep it separate, and you don't have no footage of this bag being removed.
No, because you hit my body cam.
Well, that'll be all the questions.
Any, other questions?
No, Your Honor.
Can the witness be excused?
No, I'd ask that you remain under subpoena.
So you're still under subpoena. You can leave the courtroom, however you may be recalled as a witness.
Yes, sir.
Mr. Sutherland, may call your next witness.
At this time, State of Sam Catalani.
All right. So what just happened? They let the jury take a break. I don't know if I cut that out or not. I was making the poll, so I wasn't listening to what happened. But they excused the jury for like a 15-minute break, and they're about to start discussing some things.
Come on forward. Stand and raise your right hand, clerk will get you sworn.
You solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, and nothing but the truth. Yes. Thank you.
You may have a seat. Mr. Sutherland, you may inquire whenever you're ready.
Morning, sir. Hi. You please introduce yourself to the jury.
Sure. Hi, my name is Sam Catalani.
Where are you employed?
I'm employed with the Florida Department of Law Enforcement.
What do you do for FDLE?
I'm a crime laboratory analyst supervisor of the Seized Drugs Department.
What is the seized drug?
All right, guys, I'm really sorry. I jumped ahead. I was creating the poll and I forgot this witness came up. He's only up here for about 2 minutes, so I easily forgot of his testimony. So yeah, the jury hasn't been excused yet. This is the next witness.
Department, what do you guys do?
Basically, we analyze evidence for the presence or absence of controlled substances.
How long have you worked for FDLE in the seized drugs department?
For almost 25 years.
What type of education, training, experience do you have that allows you to do your job?
I have a bachelor's of science majoring in biology. I've completed FDLE's training program of the seized drugs discipline, and I also undergo continuing education courses yearly.
In your 25 years with FDLE, how many times would you say you've had occasion to analyze a substance to determine whether it's a controlled substance or not?
Over 30,000.
Have you ever testified as an expert witness in court before?
Yes,
How many times?
approximately 400.
All right, it's time to state with tender the witness.
Mr. Beecham, any questions? Based on Mr. Carolina's qualifications.
No.
All right, Mr. Carolina will be able to give his opinion. Mr. Southern, you may continue.
Mr. Catalani, were you asked to analyze items of evidence in this case?
Yes,
How many items were you asked to analyze?
there were 2 items submitted.
May I approach?
You may approach.
I'm going to show you what's been marked for identification in States Exhibit, what's been admitted into evidence in States Exhibit 2 and 3. They correspond with the FDLE issue, numbers 1 and 2. Okay. You take a look at those for me, please. So those are the 2 items that you were asked to analyze.
Yes, they are.
Can you tell the jury what you do as far as your analysis goes when you receive items like this?
For anything that's not a plant material, I typically weigh the material, and that's just the substance, not packaging or anything. So I get a weight, and then I perform 2 instrumental analyses.
And what is the purpose of doing those 2 instrumental analyses?
The two instrumental analyses are used for me to identify the material.
Yes, they did, Aaron. And I barely got the verdict. I was about 45 seconds behind. And the clip with the verdict was a completely separate video. And it was only about a 2-minute video. So I kept refreshing. But I knew this was happening today. I had the time. I scheduled it. And I was waiting for it. So, yeah. So here we go. But yeah, I do miss 45 seconds of the verdict, but we do get to hear the verdict. We just don't get to hear the jury walk out, I guess. I don't know.
Did you do that with both of these substances?
Yes.
I want to talk about States Exhibit 2. I believe that's FDLE item number 1. First, were you able to determine how much that substance weighed?
I was.
And what was the weight of that substance?
It was 11.29 grams.
And were you able to determine what that substance was?
Yes.
What was that substance?
I identified cocaine.
And States Exhibit 3, that is FDLE item number 2. Were you able to weigh that substance?
Yes.
And what was the weight of that substance?
The total weight was 15.17 grams, plus or minus 0.20 grams.
And that 15 grams, I think you testified earlier, that is the weight of the substance alone and not any packaging that it's in. Correct?
Yes.
And were you able to determine what that 15 grams of substance was?
Yes.
And what was that substance?
I identified methamphetamine.
All right, say there's no further questions.
Mr. Beecham.
So you didn't get any powdery substance to test?
The only thing I have to test was this white chunky substance and some multicolored tablets.
And, was it labeled where they came from? Like exactly? Police submission did it. Submit one, actually. Not really.
It doesn't mention where it came from on the evidence.
I don't have any question.
All right, can the witness be excused?
Yes, Your Honor.
Or you may go about your day.
Thank you.
All right, this on state rests.
All right, ladies and gentlemen, this is the appropriate time to take our morning break. We're going to take a 15-minute break. We'll start back a little after 10:30. Leave your notepads in the courtroom. Do not discuss the case amongst yourselves. You do not check any media sources or use your electronic devices to find out any more about the case we know right now. We'll call the deputy in the back and he'll tell you where to go for your break. Hold on just a second. Let's get the door closed, Mr. Beecham. All right, go ahead, Mr. Beecham.
I like the motion for a judgment of acquittal. Legal,
All right, I'm gonna rewind this about 10 seconds. I'm turning my volume all the way back up so you can hear him. But if we can't hear him, he's motioning for an acquittal. I'm gonna rewind it just a bit. You know what? I'm just gonna play it from here. I jacked the volume up. Hopefully, it's not too distorted.
Or use your electronic devices to find out any more about the case we know right now. We'll call the deputy in the back and he'll tell you where to go for your break. Hold on just a second. Let's get the door closed, Mr. Beecham. All right, go ahead, Mr. Beecham.
I like the motion for a judgment of acquittal. Legal, insufficient of the evidence. State has failed to establish any of the elements of knowledge, domain, and control. This case is wholly circumstantial. Being the passenger. Has no telling how long I was in the car and I was in the car before we were at the car.
Mr. Sullivan, state's response.
All right, I'll try to decipher that for anyone who didn't hear it. It's a motion for an acquittal based on he said like based on the elements. They didn't prove possession. They just said it was in the car. Something like that. And that's what he's been arguing this entire time. But I will say this. This is the point that you would motion that because the state rested, right? So that's when you would put that motion. So I was talking to Lone Wolf earlier about this case, and I told him like I was kind of bored because he wasn't doing the SovCit stuff. It was still interesting, so I was watching, but I was like, you know what? I don't know if I can play this. And then you know what? This guy is actually doing the things that you should do as an attorney, just not asking the right questions, not doing everything the correct way. I mean, he's in his jail uniform, but he's not doing a terrible job.
At this point in time, the court has to look at the evidence in the light most favorable to the state, and there's sufficient evidence for this case to move forward to the jury. While the controlled substances were found in the back, there was a white powdery substance that was found along with the controlled substance that was identical to white powdery substance that was found in Mr. Beecham's pocket. That is sufficient evidence to tie Mr. Beecham to the items in the back, and this case should move forward to the jury.
I am going to deny the motion for judgment of acquittal. I believe the state has met its burden so far as getting it to the jury. Mr. Beecham, do you anticipate on calling any witnesses?
No, sir.
Do you anticipate on testifying yourself?
No, sir.
Okay. Well, let me go ahead. I'm going to swear you in, and I'm going to ask you a few questions about your decision not to testify. And that's all the questions I'm going to ask, okay? Okay.
Yeah, I'm going to deny that, Lone Wolf. I mean, he did claim the Treaty of Florida when he got pulled over. Smart dude. Was he able to spend the time in jail and study and figure out how to do this? Yeah. He figured out the proper process. And he dropped the Treaty of Florida stuff. But smart dude for actually thinking that was going to work at first, nah.
Go ahead and just raise your right hand to affirm. You don't have to swear.
To affirm the testimony about you, the whole truth.
All right, Mr. Beecham, state your name.
Josiah Beecham.
Mr. Beecham, you know you're representing yourself at this time. Is that correct?
Yes, sir.
And you have a right to be represented by an attorney. Do you still wish to represent yourself at this stage in the proceedings?
Yes.
And you've made a decision not to testify. Is that correct?
Yes, sir.
Do you understand you have a right to testify?
Yes, sir.
Do you understand you have a right to remain?
This happens in every jury trial. Generally, it's behind the scenes, and the defense, your attorney is saying this, and it's generally, maybe put in a motion beforehand. My client's not testifying. He's waiving all of his rights, and he's going to remain silent. That is what generally happens. So because there's no motion on the record, or he's got to actually put this on the record and say you're not testifying. You understand you can, but you're using your right to remain silent. We're not going to hold that against you. So all they're doing is putting it on the record right now.
Silent. The only person who can make the decision whether you testify or remain silent is yourself.
Yes, sir.
Okay, if you made the decision to testify, I'd give you an opportunity, maybe in a more narrative form, to testify since you're representing yourself. However, you would be subject to cross-examination by the state. You couldn't just stop at that point in time. You understand that?
Yes, sir.
You understand if we were going to take a break, and if after the break you change your mind, you wish to testify, do you understand that until you rest your case that you can make the decision to testify? Do you understand that?
Yes, sir.
Okay. All right. Anything else we need to address at this time?
Your Honor, I don't know if you want to do the charge conference or wait.
Yes, go ahead and do the charge conference. Mr. Beecham, do you have a copy of the jury
He
instruction?
does there in that book that I gave him right behind.
Have you had a chance to look at it?
Very instructive.
It should be at the end. I've got the same book, I think.
Yeah, Your Honor. It's everything after those first 3 photographs.
No, I found this out because I've looked it up, and I've made this comment before, and your guys' response to this comment is hilarious. I say often about this whole area, this Bay County area, it's the far western part of the state. It's actually in the central time zone, and I didn't know that there was a central time zone part of Florida, but this area is closer to Mississippi than in Alabama than it is to, Orlando. So, which is why Judge Van is constantly saying, you an Alabama fan? You a Mississippi fan? It makes sense now. It all makes sense. And it took me so long to figure that out. All right, let's keep going. If this is another part, going through the charge document is slow, not terribly exciting. If you guys want to watch this, we can. If you want me to skip it, I can skip it too.
And Mr. Beecham, if you need some time, if you haven't looked at it, if you want to take some time and review them, we can review them before the charge conference. Beecham, some are present. Mr. Beecham, have you had a chance to review the jury instructions?
Yes, I have, Your Honor.
All right, let's go through them.
All right, yeah, this isn't anything exciting. It's about as exciting as the jury instruction. So I'll skip to the closing when the juries come back in, because Mr. Beecham doesn't do any SovCit stuff, doesn't object to anything. They're literally just going through the charging document, which is what they're gonna send back to the jurors, right? So this isn't exciting. I'm just clicking through. Yeah, man, this took like 20 minutes too. It's a good place to skip. Hold on. I'm just going to play it for a second.
You've been able to contact the officer?
Yes, Your Honor, he's on his way back.
Thanks.
Oh, yeah, that is one thing that happened. I'm glad I played it there. Mr. Beecham did decide he wanted to bring back the officer for like one more question, but they've already sent him home. They've already sent him home, and they had to call him back. So kind of annoying on the officer's part. Obviously, an officer that's already kind of PO'd that he's being questioned by this guy.
You know what I'm saying? It was a clear bag, and then he
I
also.
understand, but the question is, you can argue that.
All right. They're arguing the back part again, so we'll just play it from here.
I'll take judicial notice, but there's no allegations, and I've seen no evidence of perjury.
All right, I want to go back a little further. The defendant called him back. Now, there was a part, if you guys need to go back and watch the video I did a couple days ago in the jury selection, because the defendant is, jumping up and down saying the officer committed perjury. And the prosecutor's like, you can't say the word perjury in trial because the word perjury will put a certain stigma in the jurors' heads and not trust the officer, so you can't use it. So he's bringing it up. Probably shouldn't have fast forwarded this far, but I didn't skip anything too exciting, but I'll play it from here.
Yeah, Sean, I think 8 would Probably,
I think 8 should stay in.
yes.
Don't you, Mr. Beecham?
Nine and 10, I would like to stay in as well.
Well, I mean, there's no evidence of anybody being convicted of a felony or misdemeanor involving dishonesty. And there's no reputation testimony that's come in.
I had the allegation of perjury up and
I'll take judicial notice, but there's no allegations, and I've seen no evidence of perjury. I understand.
He said he testified in that preliminary hearing. I'll testify. Will is saying he had his camera on. That's like basically right now. That camera exonerating you.
Any objection to leaving 10 in, Mr. Sullivan?
Yes, Your Honor, there's been no repetition testimony.
There has been no representation. I'm gonna agree with that. So 9 and 10 will come out. I'm gonna leave 8 in. That's the inconsistent testimony. The rest of those.
What about the fact of the bag? He kept saying it was a clear bag, and then he also.
I understand, but the question is, you can argue that, but there's been no one to come in and testify he has a reputation for being dishonest. So that has to be independent testimony of that or evidence. Does that make sense?
Yes, sir, that makes sense.
Okay. On page 6, those are all, looks like standard instructions. Any issues with those? That's about the expert testimony. It's probably entirely proper for a lawyer to talk to a witness, and the jurors have their own, they can come to their own conclusion about the credibility of any witness.
Seven comes out.
7 comes out. And on page 8, if you've read page 8 yet? Okay.
You already gave this instruction.
Yeah, it's the, that was a preliminary instruction.
I would have finished that for you, Jedi. I would have finished. I'm a Illinois fan. I was born there. My dad went there, so I grew up an Illinois fan, which is why I'm not an Ohio State fan. But graduated from the University of Cincinnati, so I'm a Bearcat, but I grew up an Illinois fan. So yeah. You say ILL in front of me, I'll always respond with INI. Also, Jedi, speaking of which, thank you so much for the very generous Venmo a few minutes ago. I appreciate it. Thank you so much, Jedi.
This is the instruction. You can ask for both of these to be given again. I'm going to give the instruction back exercise. If now I don't have to, but I mean it's a instruction that they're not consider.
You don't gotta give it again.
Sir,
You don't have to give it again.
you sure?
It was probably 30 to 45 minutes. It was not long. I kept refreshing because you can't turn on their notifications. They have them disabled. So I was refreshing every 30 seconds to a minute to get it. But yeah, it was probably 30 to 45 minutes.
Basically, what that instruction is saying, they're not to be concerned that you did or not take the witness stand, and they should not give that any weight. Basically, what I'm telling them, they can't view that as admission or guilt to be influenced in this decision in any way. They can't hold it against you because you exercise your right to not testify. And basically, again, it lets them know that it's the state's obligation to prove the accusations against you. You understand?
Yes, sir. It sounded kind of sound misleading.
Well, let me read it to you and let you listen to it while I read it, okay?
Right.
Okay? The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case.
You can leave it here.
And then the general rules of deliberation, those are all standard, page 9. Did Mr. Beecham have a break? Yes. Thank you.
All right, I don't really know what we're waiting for. The officer to come back, maybe?
Just let me know when you're ready, sir. Are any problems with the general rules? And then you may find that defendant guilty as charged or in the information or not guilty. And it has to be unanimous verdict. Have you had a chance to look at the verdict form, sir?
I didn't realize they were still going over this. I'm going to fast forward it. I walked away. I had to use the restroom for a second, so I was gone for 10 seconds. And I was hoping the jury was back already. It's not. Like, the prosecutor's not even at the table.
I'll wait on him, but he texted me, he's here, so he's.
All right, now the jury's coming back in. All right, here we go. Everyone's standing. Well, besides the judge, why isn't the judge standing? Maybe the jury's not back yet?
Going forward, sir, take your seat back there.
Oh, officer's back. Okay, let's go.
Officer, if you're still under oath, just have a seat speaking to the microphone. Mr. Beecham, you may inquire when you're ready.
Officers, you know that these are the two. I'm being charged with.
Mr. Beecham, you may want to speak up where the jury can hear you, okay?
Okay, I'm sorry. Are these the two exhibits that I'm being charged with here today?
Yes.
Are any one of these the substance that was allegedly found in my pocket?
It was not in your pocket.
That was an important question. They're trying to link him to the substances that were in the bag and the substances that were in his pocket. And he just said, yeah, anyways, I'll rewind it a little bit, but no, Mr. Beecham did not rest. He did not rest. So when the prosecutor let the officer leave before the defense rested. That's why this was a big deal. They took a break, but the defense didn't rest, only the state did. So that's why this is a big deal. Okay, I'm going to rewind it 10 seconds because I paused it right after this question, and it's an important one.
I'm being charged with.
Mr. Beecham, you may want to speak up where the jury can hear you, okay?
Okay, I'm sorry. Are these the two exhibits that I'm being charged with here today?
Yes.
Are any one of these the substance that was allegedly found in my pocket?
It was not in your pocket.
And so the alleged substance that you said was found in my pocket was put with some other substance and weighed up separately, but not those two.
Correct.
Okay, that's all. I just wanted to get that to the jury.
Okay. I've got no calls to do, Your Honor.
Mr. Beecham, you call your next witness.
That'll be, I rest my case, Your Honor.
Okay, any rebuttal?
No, Your Honor.
Officer Zip, you're free to go, you're released, and you're free to go about your day.
All right, thank you, sir.
Yes, sir. We're just. Both the state and the defendant have now rested their case. Mr. Sullivan and Mr. Beecham will now present their final arguments. Please remember that what Mr. Sullivan and Mr. Beecham say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. Mr. Sullivan, whenever you're ready.
Thank you, Your Honor. Madam Clerk, if I could have the screens, please.
All right, so before the state starts their closing argument, Lone Wolf, you saw my chats, team, man. You saw my chats. I was telling you it was boring, and then all of a sudden I came out with a holy F. Like, I got excited real quick. Like, how? What just happened? What just happened?
All right, ladies and gentlemen, as I told you earlier this morning, in a few moments, the judge will give you the law that will apply to the evidence that you've heard. I also told you this wasn't a complex case. It's pretty simple. Things may have gotten a little confusing earlier. I'm going to attempt to try to clarify some of that for you real quick. But like I told you, I have to prove three things beyond a reasonable doubt, count one. The first thing that I have to prove is that the defendant knowingly possessed the substance. Second thing I have to prove is that that substance was methamphetamine. And the third thing I have to prove is that methamphetamine weighed more than 14 grams. The real issue in this case is that first thing, whether the defendant possessed the substance. I don't think that there's any dispute that these items are methamphetamine and that it weighs 15 grams, more than 14. You heard that testimony from the FDA analyst, Sam Catalani, and I don't think Mr. Beecham's even disputed that part. The question in this case is whether he knowingly possessed this item. I'm going to come back to that in a second. Count two, I have to prove two things beyond a reasonable doubt, that the defendant knowingly possessed a substance. That's this substance here. And that the second item that I have to prove is that this substance was cocaine. Again, you heard that testimony from Sam Catalani. This is in fact cocaine. And I don't think Mr. Beecham's even disputing that. That's not the issue. The issue, like count one, is whether Mr. Beecham possessed this substance. So I want to talk about that issue, because that's really what we're here for today. Is did Mr. Beecham possess these two items? You heard the testimony that these two items were found located in a backpack in the back seat within reach of Mr. Beecham being the driver. They were also located in, the reason I have it up on the screen, it may be easier, but I'm going to try to point here. So in states 1A, this item up here at the top, that is the methamphetamine in this case, and that is also the same item that is depicted in 1C. And this is how it was found. It's just a close-up view so you can better see how it was found. This container here on the left of the photograph, that is where the cocaine in this case was located. That was found in that same location as the methamphetamine. Now, there's some talk about commingling drugs, mixing it together and where it was found and all that. This item, State's Exhibit 4. You heard the testimony, this was not tested by FDA. So the officer testified that he did a field test and the field tested positive for cocaine. At the end of the day, maybe it's cocaine, maybe it's not. Mr. Beecham's not charged for this substance, for whatever it is. But this substance is important because it directly links Mr. Beecham to these items. And it directly links Mr. Beecham to these items that he is charged with.
That's not rule the objection to start. Make your argument.
It directly links Mr. Beecham to these items because you heard the testimony and you can see the powder. It's all the same powder. And the fact that it was actually mixed together is a good thing, because if it was different, you would see the difference. And if you compare the color, it's different than the other items. But this white powder came from this container that was located with these items that Mr. Beecham was charged with, as well as the bag that was found in Mr. Beecham's pocket. And that's important because, as you heard the testimony from Officer Ziff, he had the same exact thing in his pocket that was located with these other items. Now, you heard some testimony about oxycodone, marijuana, fentanyl, things like that. You heard the testimony and saw I showed some exhibits to Officer Ziff. There were some other items that were found along with these, but those items, again, were not sent to FTLE. They were not tested. So Mr. Beecham is not charged with those items. We talked a little bit Monday about some rules, and when I talked about objections, there's rules we have to follow. Typically, I'm not allowed to present items of evidence that Mr. Beecham is not charged with, the oxycodone in this case. So when I had Mr. Officer Ziff on the stand and we were talking about what was found originally, he wasn't hiding anything. He wasn't hiding the fact that there were these pills found as well. I'm not allowed to present that to you. Mr. Beecham decided he wanted to talk about it, and at that point, now we can talk about it. And that's why I got back up on redirect and we were able to present it to him. I only bring that up because Mr. Officer Ziff wasn't hiding anything. He wasn't being evasive. It's just the rules didn't allow me to do it until Mr. Beecham talked about it himself. I say that all to say is, again, Mr. Beecham's not charged with that. Don't take that into consideration. What he's here for today, simply these two items, methamphetamine and the cocaine. And the importance of this other exhibit is because it directly ties Mr. Beecham, not only because he's in direct physical control, the ability to reach around and control those items, but because he actually had some of those items on his person. Knowledge of an item, the judge will tell you that the state has to prove that the defendant knowingly possessed these items. And there's no way for me to prove the knowledge that's in his mind. It's impossible. You have to infer knowledge. And you infer knowledge based on the other circumstances in the case. In this particular case, you can infer that the defendant knowingly possessed the items in the back of the car because he had.
Overrule this argument. You'll get a chance to respond.
You can infer that he possessed the items in the back of the car because he had one of those items in his actual pocket. I submit to you that this case is not complex. I have proven the charges beyond a reasonable doubt. In a moment, when the judge reads you those instructions, you'll see that, and I ask you to find the defendant guilty as charged. Thank you.
You're ready.
All right, ladies and gentlemen, if you weren't able to hear me quite clear today, state wants you to believe that I possess the two drugs that were there wrong. You heard from the officer, I wasn't charged. I mean, with those items wasn't on me. The one alleged was on me, say it was in a bag. He wasn't able to show you the bag to show you that it actually was the same bag. And like we said, that we're in a day of technology, we're in a day and age of technology. There was a camera existing, somehow I miraculously cut it off. On top of cutting this camera off, the items were in, like y'all seen, a container, and he said a brown paper bag. It's easy to fingerprint those items. I was in the car with another occupant, and in a jointly occupied vehicle, you cannot infer.
Objection, Your Honor, misstatement of the law.
Stand.
Well, I was in the car with another occupant as well, as you heard the officer say himself. And he said he lost sight of the other occupant when he was taking me out of the car. And we somehow lost all the footage of any items being found. And no items were scientifically tested to prove my, knowledge of these items. To prove that I had any ability or ever even came in contact with the items. They were in a brown paper bag, something that can easily be tested for prints. And he also said, you saw the containers. And so I can't dispute the weight or any of that because I didn't even know those items existed. And that's what I was trying to prove to you guys today. And the other items that supposedly ties me to the drugs allegedly found in my pocket, like we say, it wasn't video captured because I turned the camera off. That was a discrepancy of saying that he allegedly found something and put it with some other stuff to say that I had a bag or known of another bag, but I'm not even charged with it. So I had a drug on me that connects to other drugs, but I'm not charged with that drug. I'm just charged with 2 of the other drugs out of the bag. If that makes sense. That's what the state is trying to get you to believe today. Or whatever was allegedly found, whether it was a drug or not, if that makes sense. So I'm not even getting the sense of how the state is trying to elaborate this, but I know that it was a way to prove beyond a reasonable doubt that I had knowledge or was able to access dominion and control over something that was, like they're saying that was in my reach, but it was in the car with another passenger was in the car with me. And therefore, I'm asking you guys to find me innocent of this case because there was no prints or anything that connected me to those drugs. Thank you for your time.
Talked a little bit Monday about possession, whether it can be joint. Yes, there was another person in this car. He'll have his day in court. Another jury will determine his fate. Just because there's 2 people doesn't mean multiple people didn't possess these controlled substances simultaneously. Mr. Beecham said there's no scientific testing done. Well, that's not true. You heard the testimony from Sam Catalani. That's scientific testing. He told you that scientific analysis told you that, or confirms that this is cocaine and this is methamphetamine. Same white powder, same packaging, both with the controlled substances and in Mr. Beecham's pocket. And that's the key to this case. Simple as that. This isn't a case where it's in a different packaging, it's in a different container, it's a different substance. It's the exact same thing. It's the same white powder and it's packaged the exact same way as the stuff that's in the back, in the backpack, in the back of the car. As far as the body camera goes, you heard the testimony as to why there's no footage of this. Mr. Beecham's the one who was not cooperating. He was struggling with the officer, and Mr. Beecham's the one who accidentally turned Officer Ziff's body camera off during that struggle. It's as simple as that. It's not any big conspiracy that Mr. Beecham wants you to believe. It's as simple as that, ladies and gentlemen, and I ask you to find the defendant guilty. Thank you.
Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Josiah Marquise Beecham, the defendant in this case, has been accused of the crimes of trafficking in methamphetamine, possession of cocaine. As to count 1, certain drugs and chemical substances are by law known as controlled substances. Methamphetamine is a controlled substance. To prove the crime of trafficking in methamphetamine, the state must prove the following 3 elements beyond a reasonable doubt. Josiah Marquez Beecham knowingly possessed a substance. The substance was methamphetamine. The methamphetamine weighed 14 grams or more. To prove Josiah Marquez Beecham knowingly possessed a substance, the state must prove beyond a reasonable doubt that he knew of the existence of the substance and intentionally exercised control over that substance. Control can be exercised over a substance, whether the substance is carried on a person, near a person, or in a completely separate location. Mere proximity to a substance does not establish that the person intentionally exercised control over the substance in the absence of additional evidence. Control can be established by proof that Josiah Marquez Beecham had direct personal power to control the substance or the present ability to direct its control by another. Possession of a substance may be sole or joint, that is, two or more persons may possess a substance. As to count 2, certain drugs and chemical substances are by law known as a controlled substance. Cocaine is a controlled substance. To prove the crime of possession of cocaine, the state must prove the following 2 elements beyond a reasonable doubt. Josiah Marquez Beecham possessed a substance. This substance was cocaine. The definition of possession was previously read to you as a part of count 1 and applies equally to count 2. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or to prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted, as well as what they said. Some things you should consider are, did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it is called or upon the number of exhibits it is offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses, with one exception. The law permits an expert witness.
All right, I haven't paused it in a while, but there's not a lot going on. He's just reading the law off. Aaron, I got a counter to that. I would say he's driving the car. He's in possession of what's in it. He had a passenger in the car. Does that mean he's in possession of the passenger? Just saying. I like to play devil's advocate. We'll put that in your head. All right, let's finish this up.
To give his opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You should not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. You must follow the laws as set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you've heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. This case must be decided this case must not be decided for or against anyone because you feel sorry for anyone or angry with anyone. Remember, the lawyer is not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find the defendant guilty as charged in the information or not guilty. If you return a verdict of guilty, it should be for the highest offense which has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then, of course, your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. It is as follows. Verdict. We, the jury, find as the defendant Josiah Marquez Beecham as follows. Mark only one. The defendant is guilty as charged of trafficking in methamphetamine. The defendant is not guilty. That's count one. Count two. The defendant is guilty as charged of possession of cocaine. The defendant is not guilty. Mark only one of those. Signed by the foreperson and dated. A separate crime is charged in each count of the information, and although they
Yeah, no. I didn't say that. I did not say that at all. I was countering an argument someone said about a driver is in possession of everything in the car. So that's why I was making the joke about the passenger. That was my joke. I don't know any. I barely even know the state of Ohio's laws about that. So yeah, not arguing this at all.
been tried together, each crime and the evidence applicable to it must be considered separately and a separate verdict returned as to each. A finding guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged. In just a few moments, you'll be taken to the jury room by the bailiff. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on the verdict and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberations should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you've reached a verdict, you must not talk about this case in person or through the telephone, writing, or other electronic communication, such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberation. These communication rules apply until I discharge you at the end of the case.
I'm still practicing on being a 3-man. You're already up to a 4-man? Good for you. Yeah, 3-man is what I'm working on right now.
If you become aware of any violation of these instructions or any other instructions I've given in this case, you must tell me by giving a note to the bailiff. Many of you have cell phones, tablets, laptops, smartwatches, and other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats or they will be guarded by the bailiff while you deliberate. If you need to communicate with me, send a note to the bailiff signed by the foreperson. If you have voted, do not disclose the actual vote in the note. If you have questions, I will talk with Mr. Sullivan and Mr. Beecham before I answer, so it may take some time. You may continue your deliberations while you wait for my answer.
I want to stand, but the verdict part of this video is only 1 minute long. So if I skip to it, I'm gonna be all over the place. And we're at the very end of this video. So yeah, I'm not gonna skip it in case I miss it. Let's just say that. Because if I go right to the middle of it and then I have to rewind, it's not gonna have the same impact.
I'll answer any questions if I can, in writing or orally here in open court. During the trial, items will receive into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. The exhibits will be sent in the jury room with you when you begin to deliberate. In closing, let me remind you that it is important that you follow the laws spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case, even if you do not like the law.
All right. I won't interrupt it anymore. Stan asked me not to interrupt anymore, so I will not interrupt anymore. Well, one more time. I'm going to give you one more interruption.
Must be applied. You must use them. For 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate the rules we all share. Mr. Sullivan, Mr. Beach, does that actually reflect the jury instructions agreed upon?
Yes, sir.
All right. Ladies and gentlemen, just a moment, you're going to be escorted by the Taylor to the jury room. Ms. Rutgers and Ms. Moncare, you are our awesome jurors. You will not go back and deliberate. And I apologize. I know that keep you all day Monday and keep you all morning today, but we have to have 6 jurors, and many times we pick jurors on Monday, about time Friday, we have jurors that cannot serve, so that's why we have officers. I let everybody else know that because I've sent a jury back in the jury room and didn't tell them why the other jurors would go back, but they were off. And they waited for 45 minutes before they started deliberating because they did exactly what I told them to do. So that's why I let you know that. We'll send the all the evidence out there with them. Here are the instructions, also the verdict form. Take your notepads with you at this time. Leave all your electronic devices, your pocketbooks, any smartphones, leave them in your chair. The Bay County Sheriff's Office will be responsible. They will be secure.
It's your choice to stay here in the courtroom or leave.
And you can stay here in the courtroom, and I'll talk to you. Don't just stay where you're at. I'll talk to you.
Thank you so much, Sparkle Poots. I appreciate it. I just looked. There's 4 minutes left in this video. And again, the verdict is the last minute of it, so I don't know what the next 3 minutes are. But thank you so much for the super chat, Sparkle Poots.
Everyone can have a seat. I certainly appreciate your service.
Thanks, Dwight. I appreciate it.
Many times, I've run out of jurors by Friday. My people too, because I've run out. Don't have a seat. But you have provided a great service to your community, other than serving in your country's military. This is the highest honor we have. This is the highest honor we have for civilians. Come and sit as jurors. This separates us from the rest of the world. With that being said, that concludes the jury service. Go back and start your weekend, or feel free to sit in the courtroom and wait on the verdict. But thank you. You're free to leave. Gentlemen, thank you for a well-tried case.
Thank you, Your Honor.
Your Honor.
Yes, sir.
Reinstate the motion for judgment on the verdict.
Absolutely. And it'll be the same rule. All right, Mr. Stone, that's a well-tried case. And we'll be in recess until we hear from the jury. Mr. Beach, I'll take you back.
All right. Here's the point in the video that everyone's been asking for. I will let this play the rest out. Before I do, I want to call out Dwight. Thank you so much for being a member for 1 month. I appreciate it. Thanks, bud. And yeah, everyone else, thank you for watching. I know it was a long video. Can you explain what's happening? Yeah, well, he was just he just excluded the alternate jurors. That's what he was just doing. I guess one of the alternate jurors was was he a vet? I don't know, because he said thank you for your service to your country. Maybe, but he says that about jury duty, so maybe that's what he was saying. All right. Oh, Vince, you were joking. All right. I'm gonna let this video play out. Thank you everybody for your super chats, your membership milestones, and for all the PayPals and Venmos tonight. You guys are awesome. Let's play this out. While this is playing out, I'm gonna look to see if there's anyone that we can raid. So if I can find one, I'll raid one. If not, I'll see you everyone in Discord. Until tomorrow. Bye.
Everyone can have a seat, the jurors can have a seat. It's my understanding that the jurors have reached the verdict, is that correct? Who's the fourth person?
I am, sir.
Mr. Is it Pennell?
Yes,
Go
sir.
hand the verdict form. All right. Mr. Beecham, you'll rise. Madam Clerk, if you'll publish the verdict.
In the Circuit Court, 14th Judicial Circuit of the State of Florida, in Florida County. State of Florida versus Josiah Marquise Beecham. Case number 23 CF 4175. We, the jury, find as to the defendant, Josiah Marquise Beecham, as follows. Count 1, the defendant is not guilty. Count 2, the defendant is not guilty. Would say we all dated the 7th day of June 2024. Four-person Nicholas Pennell.
Does anyone wish to have the jury polled?
No, Your Honor.
All right. Have a seat.
All right, I knew I said I wasn't going to pause it again, but the video's over now. They literally cut this off right now, which I am so glad I got the verdict, because they put this video up and then they took it right down. And they deleted all the content. But yeah, not guilty. Not guilty. So this is what I'm going to say. Did he do a great job representing himself? No. Did he do a bad job? No. But he did a good enough job to persuade the jurors, or the prosecutor did a terrible job. I'm not going to say the prosecutor did a good job or a bad job, but I will tell you he's paying for drinks tonight because he lost to a pro se. A pro se that claimed that the Treaty of Florida was a reason why he shouldn't have been pulled over. Okay, let's get out of here. I'll see you guys. We are rating KCC. She's the only person on my list that's live. So we're rating KCC, and let's go ahead on Discord. You guys all have a great night. Thank you for hanging out. I know it's a very long video, but I wanted to play this all in one shot. You guys are great. See you tomorrow. Bye.
Ladies and gentlemen, I wish to thank you for your consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you're at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might simply find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. Ladies and gentlemen, thank you for your time.